066-6117 commenced with the evidence of Captain Stephanus de Bruin, who in an entirely unrelated matter interviewed accused number 3's father as to his whereabouts and telephonic connectivity. The information sought to be elicited, namely accused number 3's cell phone number, was objected to on the basis that it constituted hearsay. I ruled that the evidence sought to be adduced was admissible in terms of Section 3(1)(c) of the Law of Evidence Amendment Act, i.e. that its reception was in the interests of justice. The attempt to prove that the number furnished was indeed that of accused number 3 was once more thwarted when objection was taken to the evidence of Mr. Samir September, the manager of student records at the Nelson Mandela University. The objection to the divulgence of accused number 3's personal details captured on the university's database by September proceeded from the assumption that inasmuch as the subpoena had been issued through September's understudy, Miss Beverly Brickles, accused number 3's constitutional rights to privacy would be infringed should September produce the requested information. The objection raised was spurious and once more a blatant attempt to suppress otherwise admissible evidence. September was called as a witness, appeared of his own accord, and not pursuant to any subpoena. As adumbrated herein before, he was the person in charge of student records in the university's administration, and as such entitled to access such information. The privacy contended for was that because the subpoena had not been directed at him, he was not authorized to disclose the information sought. The argument advanced is simplistic and untenable. It is in any event clear from the terms of the subpoena that the information sought inter alia accused number 3's contact details, including any documentation wherein he had furnished the number 060-406-6117, was sought to be elicited from the university, and Brickles was merely its proxy. The information had in any event, in compliance with the subpoena, been furnished to the investigating officer. The underlying import of Section 205 is to vest the state with machinery to pursue its legitimate interest in investigating and preventing crime, and where, as in Castle, the information sought by the police is voluntarily produced, it is admissible in evidence. The task of identifying an individual with a cell number 078-986-6192 was assigned to Bosch by Swanepoel. By the simple expedient of dialing the number and informing the answerer that the number had been randomly chosen in a competition to win 500 Rand, the recipient furnished his name as Zolani Sabeko and his address as 19 Manassi Street, Sweden. Bosch's inquiries at the address the following morning led him to 12 Romulus Street in Greenbushes, where Bosch introduced himself and inquired about accused number 4's whereabouts. He sought permission to search the premises, and, armed with the requisite authority, he searched the house and found a male person in a main ensuite bedroom who identified himself as Zolani Sabeko. Having ascertained his name, Bosch informed him of his rights and asked him where his cell phone was. It could not be found. It appears from his testimony that one of the occupants, having eavesdropped on their conversation, had secreted the phone on her person. Its attempted concealment, however, failed when Swanepoel, having dialed the number, observed the lit-up screen through accused number 4's abettor's clothing and retrieved it from her. Bosch's evidence that the name furnished by the answerer, namely Zolani Sabeko, was challenged on the basis that it constituted hearsay evidence and should accordingly be ruled to be inadmissible. It is evidence from Bosch's evidence that the spontaneous declaration by accused number 4 of his personal particulars was triggered by the euphoria of his windfall, and to contend that such evidence is inadmissible is simply untenable. The further submission that it had not been proved that the secreted phone was that of accused number 4 proceeds from an entirely skewed appraisal of the evidence. It is not in dispute that when the police inquired about accused number 4's whereabouts, it yielded the answer from his mother that she did not allow him at her house. His discovery in the bedroom thereafter establishes her deceit and explains the conduct of the person who secreted the phone. It is not correct to submit, as Mr. Doberman did, that Bosch did not search for a phone. It is apposite to refer to that evidence. I searched the premises and then found Mr. Sibeko standing in the main bedroom, my lord. I identified myself to him and warned him of his rights. I then requested him to allow me to search him, as I was looking for a cell phone. My lord, I could not find a cell phone on his person, and he informed me that he had left his phone in the bedroom that he was sleeping in. When I got to the bedroom, my lord, there was an elderly lady busy making up the bed in the room, my lord. I did not find any cell phones in that room, my lord. I then requested Sir Captain Swanepoel to phone the number so that we could see where this phone is. As Captain Swanepoel was phoning the number, my lord, the Xhosa lady attempted to leave the room. I asked her where she is going to. She then turned around. She had a gown on. She turned around and opened the gown like this, showing us that she has got nothing in her possession. As she opened the gown, my lord, you could see her cell phone's face lighting up in her gown pocket. That phone was then handed over to us, my lord, and we identified it as the phone that we were looking for, that Mr. Sibeko was using at the time. A cursory examination of the aforegoing tittle of evidence establishes the want of the submission. As preceded in the further particulars furnished to accused numbers 3 and 4, the state's case against them is based upon cellular phone billing and plotting and the card track data. Thus, in order to establish that there was contact between the cellular numbers of accused numbers 3 and 4 and Vumazonke, the state called Mr. Damesh Kanti, a manager in the Law Enforcement Agency Liaison Services of MTN. Kanti had deposed to an affidavit pursuant to the provisions of Section 15.3 and 4 of the Electronic Communications and Transactions Act, ECTA, and when referred thereto in chief, confirmed its correctness and expanded thereon with reference to certain cell phone towers. His cross-examination by Mr. Doberman stood over to afford the latter to consult his own experts, and when the matter resumed the next day, he sought a declaration that Section 15.4 of ECTA was unconstitutional by reasons of what he termed were its reverse onus provisions. After hearing the parties, I handed down a written judgment dismissing the application by reason of its procedural deficiencies. The ruling precipitated a further challenge to the admissibility of the cell phone records on the basis that, and I quote, there is no authority in Section 205 which authorizes a person who is prohibited from divulging merely because that person had been subpoenaed in terms of Section 205, close quotations. Finding succor in the judgment of the Constitutional Court in Nell v. LaRue, Eno and others, 1996 1 SACR 572cc, and the provisions of the Regulation of the Interception of Communications and Provisions of Communications-Related Information Act RICA, he submitted that neither Kanti nor any other proxy of a cell phone service provider had authority to divulge the contemplated information. The submissions advance misconstrue entirely the judgment in Nell, the non-applicability of RICA to the issue raised, and ignores the express provisions of ECTA, which regulates the admissibility and evidential weight of data messages. Section 50 of ECTA provides as follows. 15. Admissibility and evidential weight of data messages. In any legal proceedings, the rules of evidence must not be applied so as to deny the admissibility of a data message in evidence A on the mere grounds that it is constituted by a data message, or B, if it is the best evidence that the person adducing it could reasonably be expected to obtain on the grounds that it is not in its original form. 2. Information in the form of a data message must be given due evidential weight. In assessing the evidential weight of a data message, regard must be had to A, the reliability of the manner in which the data message was generated, stored and communicated. B, the reliability of the manner in which the integrity of the data message was maintained. C, the manner in which its originator was identified. And D, any other relevant factor. 4, a data message made by a person in the ordinary course of business, or a copy or printout or an extract from such data message certified to be correct by an officer in the service of such person, is on its mere production in any civil, criminal, administrative or disciplinary proceedings under any law, the rules of a self-regulatory organization or any other law or the common law, admissible in evidence against any person and rebuttable proof of the facts contained in such record, copy, printout or extract, and it is against this backdrop that the evidence to which I have hitherto adverted is to be assessed. Although various propositions had been put to Conti, Johanna Petronella Heineke and Hilda Duplessis concerning the range of towers and transmitters, the accuracy of the information gathered thereby, and the maps generated utilizing such information, their testimony stands uncontroverted. The aforegoing testimony ushered in Ms. Teresa Heather May Buerta, an investigative analyst who compiled a comprehensive report detailing her analysis of the communications between the key figures involved. Her report, Exhibit EB, contains copious references to cell phone towers depicted on a raft of maps. The precise location of MTN and Vodacom base stations and towers, respectively, was adverted to by Conti and Heineke with reference to further maps, Exhibits DQ and DR, and the import of their evidence was that there is no overlapping of base stations. Connectivity is dependent upon proximity thereto. Under cross-examination by Mr. Price, Conti's response to the proposition purportedly emanating from an expert that, and I quote, we are at present using a cell phone expert who has testified all over, and she tells us that it does make a difference. If Tower A, which is the nearest tower, doesn't pick up a call and the next nearest is Tower B, is it your evidence that Tower A cannot pick it up for whatever reason? Tower B will pick it up. It will not pick up that tower because we don't. We have now stopped the overlapping of base stations. I'm not sure what you are saying. Okay, back in 2007 we had 5,274 base stations countrywide. Today we have 159,000 base stations countrywide, so hence the coverage area. If a base station goes down, you're not going to pick up a signal. It is not going to move or bounce over to the next nearest base station to give you a connection. You have to be closer to that base station B, in order to connect to that base station. If you are in the strongest coverage area of base station A, you are not going to pick up coverage if that base station A is down. How long has this been like this? We have now stopped it since 2011. There is a reported case in America which I'm going to put before this court. It is a murder of a person where the American cell phone expert, I can assure you, far more qualified than you are, made calls that one of the calls was picked up by a tower 100 miles from where he was phoning. On your version, is that possible? I cannot comment on the way the base stations are set up in America, but in this country it wouldn't happen like that. It wouldn't happen like that. Heineke's evidence here in it mirrored that of Conti, and her cross-examined by Mr. Doberman was directed at establishing the possibility of overlap. Given the argument advanced, it is perhaps apposite to reproduce the relevant extracts from the record, where, in response to the question, do tower coverage areas not sometimes overlap, she responded as follows. They do, my lord, indeed. That is why you are able to hand a call over from one footprint to another footprint. So what would happen if you are in such an area and your cell phone cannot connect to the closest tower? What happens? Won't it connect to the other tower? Your call will be dropped, my lord. No, but if you are not getting a signal from the one tower, even though it is within that tower's area, but you are receiving a signal from another tower in an overlapping area, what will happen? No, my lord, if you are in transit and you move from one out of the range of one base station, your signal will be handed over to the neighboring station. But it is not a question, if you are trying to make a call, that this base station cannot cater for your call, that the neighbor will be so kind to take the call for you. That does not happen. If you are in an area, a recipient's area, or the circumference of a base station, and you are not able to make a call due to any technical reason, congestion or whatever, you will not be able to make a call. The response was anathema to accused number 3 and 4's cause, and a cross-examination stood down to enable Mr. Price and Mr. Doberman to consult their own experts, no doubt to dispute their testimony. The end result of this exercise was the somewhat belated acknowledgement at a later stage of the proceedings, after her cross-examination stood over, that her further attendance was wholly unnecessary. It would appear that whatever experts were consulted, their opinions were in harmony with that expressed by Kanti, Heinecker, and Duplessis. That this is so is exemplified by the conscious decision by Mrs. Price and Doberman not to cross-examine Duplessis, who had provided corroborative evidence. Notwithstanding the abandonment as aforesaid, at the inception of his address, Mr. Doberman handed up from the bar a bound volume entitled Accused Number 3 and 4's Bundle, incorporating a bibliography of 2 papers by Professor R.P. Coutts and Shelby and a book by one Larry Daniel. In developing his argument that the evidence adduced by the state from Kanti, Heinecker, and Duplessis carried no evidential weight whatsoever, he quoted extensively therefrom, notwithstanding the fact that none of the cited passages had been put to any of the witnesses. The articles and book are not evidence before me, and its introduction through the back door cannot be countenanced. As Stein C.J. remarked in State v. Harris, 1965, 2 essay 340A at p. 344 D to H. The contention raised in this court is that, the whole of the article not being in evidence, it was an irregularity to rely on passages therein not approved or assented to by any witness, in arriving at a conclusion unfavorable to Professor Hurst's views, and to do so without affording him an opportunity of dealing with them. In my opinion, there is no answer to the contention. Its correctness has to be conceded. The present case appears to be indistinguishable in principle from R.V. Mofokeng and another, 1928 AD 132. In that case, the allegation was that the accused had strangled the deceased. The district surgeon, however, had found no signs of violence whatsoever on the body of the deceased, and expressed the opinion that the death of the deceased could not have been caused in that way. A passage from Taylor on medical jurisprudence was put to him. The passage was to the effect that there was nothing to justify a witness in saying death had proceeded from strangulation if there was no appearance of lividity or other violence about the neck. He agreed with this. In summing up to the jury, the presiding judge, after stating that counsel for the defense had represented Taylor to the district surgeon as an authority and that the latter had accepted him as such, mentioned another passage in the same book to the effect that it is possible that strangulation may leave no visible signs of violence. That passage had not been put to any witness. This court held that what the presiding judge had done was undoubtedly irregular. The opinion of this writer on this subject, or any subject, was not and could not be evidence in the case. It is only possible to read such opinions to a witness and to ask him whether he agrees or disagrees with it. If he does, the opinion becomes the evidence of the witness. If he does not, there is no evidence before the jury supporting the notion. This is the trite law stated in the textbooks of the subject. It is against this backdrop that the evidence adduced against accused numbers 3 and 4 falls to be assessed. The cell phone records establish that prior to 7 April 2015, there was no communication whatsoever between Vumazonke, accused numbers 3 and 4. As adverted to earlier, the video and audio footage demonstrates quite unequivocally that it was in the contemplation of accused number 1 that Vumazonke would solicit support to execute his mandate. After hiring the ETIAS from ZEMS on 7 April 2015, there are no fewer than 5 communications between Vumazonke and accused number 4, 8 communications between him and Kusta, and 4 communications with accused number 3. The inference can thus properly be made that this was the assemblage to execute the diabolical plan. Thereafter, a pattern of reconnaissance and surveillance emerges, commencing with the trail from Vumazonke's residence in KwaNobuhle to Mswanapul's residence in Ruth Street on 13 April 2015. The ETIAS leaves Vumazonke's residence at 0511 en route to Mswanapul's residence. Vumazonke communicates with accused number 4 on no fewer than 5 occasions between 0528 and 0553. The reasons for the reconnaissance thence is apparent from Exhibit AY1, where Sione narrates having pointed out Ms. Swanepoel's residence to Vumazonke as a possible locale where the deceased could be executed. It was, on the evidence adduced, one of several possibilities where she could be killed. 14 April 2015. The undisputed evidence establishes that accused number 4 phoned Vumazonke on no fewer than 5 occasions and received 2 calls from him. This collaborative effort, now with the inclusion of Sione, appears clearly from Sione's cell phone records. The data extracted from the cell phone records and the card track data pertaining to 14 April 2015 demonstrates the collusive nature of the relationship between Vumazonke, accused number 4, and Sione. The card track data reveals that the ETIAS stopped outside Sione's gym in Tonjeni Street, New Brighton at 09:52. At 10:01, it leaves New Brighton, and at 10:09 turns into Deacon Street. At 10:56, it is positioned in North Street, where Jade taught at Ribier College. Sione's cell phone records establishes that he was in the ETIAS. Between 10 and 11 that very morning, Vumazonke communicated with accused number 4, and the purpose could only have been to keep him abreast of the reconnaissance. 15 April 2015 commences with no fewer than 9 communications between Vumazonke and accused number 4, the first in the early hours of the morning, i.e. 04:33, whilst Vumazonke was still at his residence in KwaNobuhle. After the ETIAS leaves at 04:54, Vumazonke communicates with accused number 4 on 5 occasions and once with accused number 3. The billings establish that the 3 calls between 04:33 and 05:01 was made by accused number 4 to Vumazonke. What happens thereafter is illuminating. The card track data shows the ETIAS leaving Vumazonke's residence at 04:54. At 05:23, it stops and the ignition is switched off at Njoli Street, Port Elizabeth. The cell phone data establishes that at that time both Vumazonke and accused number 4 received reception from the Ulundi Towers. At the time of the cell phone communication between accused number 4 and Vumazonke at 06:22, the ETIAS is in Vandestel Street in close proximity to Jade's home. Immediately after this call, the card track data records the ETIAS's speed at 74 kilometers per hour, followed by heavy braking and turning into Deacon Street. It then travels to Mswanapul's residence in Glenade and thence to Ribier College. The absence of any cell phone communications between accused number 4 and Vumazonke impel the inference as the only reasonable one that after 06:20 and until 08:47 they were co-occupants of the ETIAS. The aforementioned data established a similar pattern on 16 April 2015. The ETIAS departs from Vumazonke's residence at 04:11. It arrives at Sione's gym at 05:15, departs and returns a short while later before leaving New Brighton and travelling to the deceased's home. On its journey between 04:26 and 05:11, There are no less than 20 communications between accused 4 and Vumazonke. At 06:20, both their phones received receptions from the Linton Grange Tower, and a call is made inter partes. The inference may properly be drawn that accused number 4 entered the Etios whilst in the reception area and was an occupant throughout the evening's events. Immediately thereafter, the Etios starts up, travels to Deacon Road and thence to Ruth Street, where it arrives at 06:29 before returning to Deacon Street. The Etios then travels to Makanda Street, and lo and behold, accused number 4 receives a call whilst in the reception area of the Makanda Tower. The irresistible inference is that accused number 4 travelled thence in the Etios. Although the card track data establishes that the Etios was not in the vicinity of the deceased home on 17, 18 and 19 April 2015, its previous sojourns in the immediate environs is suggestive of the fact that the surveillance had yielded the required information as to the deceased's precise movements, and the intelligence garnered set the stage for the coup de grace on 21 April 2015. The fact that the data does not establish that accused number 4 was present on 21 April 2015 does not inure to his benefit, nor does the absence of any direct evidence implicating him in those events avail him. In the preceding paragraphs, I have adverted to the circumstantial evidence against him, and it is apposite to restate the proper approach to its evaluation, articulated thus in State v. Reddy and others, 1996-2, SACR 180 at P6C to page 9E. In assessing circumstantial evidence, one needs to be careful not to approach such evidence on a piecemeal basis and to subject each individual piece of evidence to a consideration of whether it excludes the reasonable possibility that the explanation given by an accused is true. The evidence needs to be considered in its totality. It is only then that one can apply the oft-quoted dictum in R. V. Bloom 1939-188 at 202-203, where reference is made to two cardinal rules of logic which cannot be ignored. These are, firstly, that the inference sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts must be such that they exclude every reasonable inference from them save the one sought to be drawn. The matter is well put in the following remarks of Davis A.J.A. in R. V. de Villiers, 1944 A.D., 493 at 508 to 509. The court must not take each circumstance separately and give the accused the benefit of any reasonable doubt as the inference to be drawn from each one so taken. It must carefully weigh the cumulative effect of all of them together, and it is only after it has done so that the accused is entitled to the benefit of any reasonable doubt which it may have as to whether the inference of guilt is the only inference which may reasonably be drawn. To put the matter in another way, the Crown must satisfy the court not that each separate fact is inconsistent with the innocence of the accused, but that the evidence as a whole is beyond reasonable doubt inconsistent with such evidence, with such innocence. Based on evidence 10th edition 297 at 261 put the matter thus: the elements or links which compose a chain of presumptive proof are certain moral and physical coincidences which individually indicate the principal fact, and the probative force of the whole depends on the number, weight, independence and consistency of those elementary circumstances. A number of circumstances, each individually very slight, may so tally and confirm each other as to leave no room for doubt of the fact which they tend to establish. Not to speak of greater numbers, even two articles of circumstantial evidence, though each taken by itself weigh but as a feather, join them together, you will find them pressing on a delinquent with the weight of a millstone. Thus, on an indictment for uttering a banknote, knowing it to be counterfeit, proof that the accused uttered the counterfeit note amounts to nothing or next to nothing. Any person might innocently have a counterfeit note in his possession and offer it in payment. But suppose further proof is to be adduced that shortly before the transaction in question he had another in place and to another person offered in payment another counterfeit note of the same manufacture, the presumption of guilty knowledge becomes strong. Lord Coleridge and R.V. Dickman, Newcastle, Summer, Caesars, 1910, referred to in Wills on Circumstantial Evidence, 7th edition, at 46 at 45260, made the following observations concerning the proper approach to circumstantial evidence. It is perfectly true that this is a case of circumstantial evidence and circumstantial evidence alone. Now, circumstantial evidence varies infinitely in its strength in proportion to the character, the variety, the cogency, the independence one of another of the circumstances. I think one might describe it as a network of facts cast around the accused man. That network may be a mere gossamer thread, as light and as insubstantial as the air itself. It may vanish at a touch. It may be that, strong as it is in part, it leaves great gaps and rents through which an accused is entitled to pass in safety. It may be so close, so stringent, so coherent in its texture that no efforts on the part of an accused can break through. It may come to nothing. On the other hand, may be absolutely convincing. The law does not demand that you should act upon certainties alone. In our lives, in our acts, in our thoughts, we do not deal with certainties. We ought to act upon just and reasonable conviction, founded upon just and reasonable grounds. The law asks for no more, and the law demands no less. Accused number 4 chose not to testify, and his failure to do so must redound to his detriment. As adumbrated herein before, the evidence adduced establishes beyond any reasonable doubt that in order to execute his mandate, Vumazonke was perforce obliged to recruit others. Thus, Count 1 alleged a conspiracy to commit murder in contravention of Section 18(2)(a) of the Writers' Assemblies Act. It is therefore instructed to emphasize its essential terms, succinctly articulated by Boshoff J. in State v. Cooper and others, 1976, 2 essay, CR 875, T at 879. A conspiracy normally involves an agreement, express or implied, to commit an unlawful act. It has 3 stages, namely 1, making or formation, 2, performance or implementation, and 3, discharge or termination. When the conspiratorial agreement has been made, the offence of conspiracy is complete. It has been committed and the conspirators can be prosecuted even though no performance has taken place. But the fact that the offence of conspiracy is complete at that stage does not mean that the conspiratorial agreement is finished with. It is not dead. If it is being performed, it is very much alive. So long as performance continues, it is operating, it is being carried out by the conspirators, and it is governing or at any rate influencing their conduct. The conspiratorial agreement continues in operation and therefore in existence until it is discharged or terminated by completion of performance or by abandonment or frustration or whatever it may be. While the conspiratorial agreement is in existence, it may be joined by others and some may leave it. The person who joins it is equally guilty. Although the common design is the root of a conspiracy, it is not necessary to prove that the conspirators came together and actually agreed in terms to have the common design and to pursue it by common means and so carry it into execution. The agreement may be shown, like any other fact, by circumstantial evidence. The detached acts of the different accused persons, including their written correspondence, entries made by them and other documents in their possession relative to the main design, will sometimes of necessity be admitted as steps to establish the conspiracy itself. It is generally a matter of inference deduced from certain acts of the parties concerned, done in pursuance of a criminal purpose in common between them. If the conspirators pursued by their acts the same object, often by the same means, some performing one part of the act and others another part of the act, so as to complete it with a view to the attainment of the object they were pursuing, the conclusion may be justified that they have been engaged in a conspiracy to effect that object. The question to be answered is, had they a common design and had they pursued it by common means? It is to be noted, however, that when the object of the conspiracy has been agreed upon, it is not necessary that any particular means or devices for attaining the object be agreed upon. The data to which I have adverted establishes a course of conduct directed to the achievement and pursuance of one criminal design. The sheer audaciousness of their mandate required a collaborative effort, and their presence in and about the deceased's home and places frequented by her attest to the common purpose shared by them, namely to kill the deceased. Accused number 4's continued presence with Vumazonke over the 3 days ineluctably compels the conclusion, as the only reasonable one, that he was privy to the conspiracy, had reconciled himself therewith, and shared in the common design. The fact that there is a dearth of evidence proving that he was at Jade's place of execution is entirely irrelevant. The offence of conspiracy continues and is in existence until the common design is discharged. Mr. Stanto, however, submitted that given the common design of the collaborators, the proper verdict should be one of murder. The case cited by him in support of this submission, however, provides no authority for the proposition advanced. The facts are wholly distinguishable. The fact that it cannot be proved that accused number 4 was present during the shooting is, however, entirely irrelevant. Count 1 encompasses a charge of conspiracy to commit murder, and, as I have alluded to, the facts objectively establish the conspiratorial agreement to found a conviction on count 1. The contract data establishes that the Etios left Vumazonke's home at 05:24 on 21 April 2015 and travelled to New Brighton in close proximity to accused number 3's residence. This was no mere coincidence. At 05:24, Sione and Vumazonke were in telephonic contact. During the course of the previous evening, there was communication between Vumazonke and accused number 3, and thereafter Kustar. After leaving New Brighton, the Etios travels towards the deceased's residence and circles the complex 3 times. Between 06:13 and 06:17, Vumazonke communicates with Kustar on 5 occasions, and at 06:26 and 06:27 there are 2 further communications between accused number 3 and Vumazonke, the latter calling the former. At the exact time of the call, when both receive reception from the Linton Grange Tower, the Etios is in Oscar Street. It then travels to Deacon Street, where, on the probabilities, the deceased was bundled into the vehicle before it sped off. The only reasonable inference to be drawn from the data is that Vumazonke alighted from the vehicle whilst accused number 3 drove off, no doubt not to arouse suspicion. The turning and braking of the vehicle shortly thereafter and the increase in speed to Deacon Street attest to Vumazonke observing the deceased, hence the call to accused number 3 to return to the complex. Accused number 3's presence in the vehicle is furthermore established by the reception received from the Rocklands Hatchery Tower vis-à-vis the call at 07:04. The aforegoing negates any suggestion that accused number 3 was not at the scene when the deceased was shot. The evidence furthermore establishes that he was at Kwanabushle when money was withdrawn from Jade's account, and that he returned to Port Elizabeth in the Etios, leaving Vumazonke behind in Kwanabushle. Vumazonke's detailed billing establishes that he remained behind in Kwanabushle, and this finds corroboration from his aunt Zuleka Zakani, who narrated the circumstances surrounding his arrival at her home on the morning of 21 April 2015. The cell phone billings furthermore establish that between 11:04 and 11:24, accused number 3's phone received reception from the Kwazakele deck tower, while the car track data establishes that the Etios travelled from Kondabushle to New Brighton, where it stopped in Boko Street and the ignition switched off. The data further records that at 11:24, the Etios was switched off in Parliament Street, in close proximity to the Spilkin Tower building, whence accused number 3 received a call at 11:33. The data thus conclusively establishes not only his association, but occupation of the Etios at all relevant times after leaving the scene of Jade's murder. The aforegoing analysis of the data, extrapolated from the tracking unit and the cell phone billings, prove accused number 3's complicity in Jade's murder beyond any reasonable doubt. Sakani's evidence that accused number 4 resided at 35 Mklenge Street, Kondabushle, was sought to be excluded on the basis that I had ruled her entire body of evidence to be inadmissible. This misconception requires correction. What I ruled inadmissible was that portion of Zakani's testimony relating to the actual words conveyed to her by Vumazonki, which the state had sought to have admitted in terms of Section 3 of the Act. Her remaining evidence, including that relating to accused number 2's residential address, was not disputed and stands. The methodology employed to arrive at the verdict has obviated the need to consider and evaluate the testimony of the majority of the witnesses called by the state. It is, however, incumbent upon me to record that whilst the effluxion of time may, in certain instances, have jolted their memories, I have no reason to doubt their honesty and accept that they gave a truthful account of matters within their province. Before I conclude this judgment, it behoves me to commend the investigating team for their meticulous efforts in unmasking Jade's murderers. The criticism directed at them and the prosecutor is unfounded. Mr. Stander has properly not sought a conviction on all the counts preferred against the accused, and in summation, I am satisfied that the evidence adduced proves the guilt of the accused on the charges specified hereunder beyond any reasonable doubt. Accused number 1 is found guilty of murder on count 4 and not guilty on the remaining counts. Accused number 3 is found guilty of robbery with aggravating circumstances on count 2, guilty of murder on count 4, and not guilty on the remaining counts. Accused number 4 is found guilty of conspiracy to murder on count 1 and not guilty on the remaining counts. That concludes the judgment. Are you people ready to proceed to sentence today, or what is the position?
We've got a lot to digest. My lord, we have discussed this prior to your lordship issuing your judgment, because obviously there was always a possibility that this would happen. And unfortunately, my lord, I don't think the sentence is going to take too much time, certainly from our point of view. But obviously we've got other issues to look at, my lord, and one of the things we need to do, obviously, is study your lordship's judgment in some detail. So it's not the sentence that would take too much time, my lord, but what might happen thereafter. What I would like to suggest, of course I'm in your hands, is, and I've discussed it with Mr. Stander, is that perhaps we, also with Shalom, bearing in mind where we all are as well, my lord, in other cases, that if we could finish this matter on the 30th of November and the 1st of December, we feel, well, or the 1st of December, we feel that we'll be able to argue sentence and you'll be able to pass sentence fairly quickly. But we would like to consider, my lord, and I want to make it very clear, only consider at this point in time, the possibility of an application for leave to appeal. And if we do that, my lord, we'd like to try and do it in the same time.
Yes, certainly.
So if it suits your lordship to postpone to, subject to what my colleagues say, I think it's a Thursday, my lord, the 29th of, sorry, the 30th of November and the 1st of December. I did discuss it with Shalom, but I I don't think she's had an opportunity to discuss it with you.
Well, I'll make the necessary arrangements with the court roll.
Is that suitable as well?
Mrs. Randa?
My Lord, the date that was originally discussed with me was the 15th of November. I don't have a problem with the 15th of November. But the 30th of November and 1 December, there are certain problematic issues regarding that particular date, my Lord. I would prefer for us that we go, I don't have a problem, but if there is application for leave to appeal, that we deal with that on the 30th of November and 1 December. I don't have any objection to that, but I would like us to try and get sentence proceedings out of the way during the week of the 13th of November, my Lord. The reasons for that I would wish not to discuss in open court, and if we can't come to an agreement with regard to sentencing, I'll request if we can't maybe adjourn and discuss.
Can we do this can you people get together and tomorrow morning we sort this out?
My Lord, Mr. Stein is correct. I did mention to him that week of the 13th of November originally. Mr. Doberman's involved in a trial for the whole week. Excuse me, I would be available the Thursday and Friday. In other words, the 16th and the 17th. But the problem is Mr. Doberman. My Lord, I wonder if we shouldn't just have a quick chat in chambers. Perhaps I'm missing something, but if we can do the application for leave to appeal, assuming there is one, on the 30th and the 1st, I don't see why we can't do the sentence in that part. In that time, Mr. Stuckey. Can I just approach him quickly? My Lord, I also don't want to mention on record what Mr. Stunder just given me. Perhaps if we can ask your Lordship just to give us 5 minutes and see what we can come up with.
Court will adjourn for a few minutes.
Ready, court?
Judge them down.
No, that's fine. It's okay. No.
to the 17th, Friday the 17th of November to 9:30.
Court please. At the court please, Madam.
Adjourn till then.
The court?